Buju, wago shindagu migizi indodem, gazaga squaji mekag, indun jaba. Today I'd like to share a perspective about the Indian Child Welfare Act. And my perspective is truly concerned. Since the end of the reservation period, when they first established reservations and began to concentrate Native people on portions of their original homeland, there's been an active assault on the Native family. What people may be a little more well aware of was that a lot of Native children were removed from their homes and sent to residential boarding schools where they were forbidden to speak tribal languages, that many of these schools like Carlisle and Haskell and so forth kept cemeteries for the kids. But what might be less commonly known is that during the summer months, when children were at these residential boarding schools, they were often placed in temporary foster care placements with white Christian families so as to prohibit these children from being back home and lapsing into their old primitive ways. And this was actually the first introduction that most of the Native population had to foster care. Now, there was a slow piecemeal transition from residential boarding schools to day schools in that educational universe. And even today, there are still a number of U.S. federal government-run residential boarding schools for Native kids. However, as we shift our attention into examining what happened in adoption and foster care practices in America, from the beginning of the residential boarding school period in the late 1800s to the present, about 1/3 of Native children have been removed from their birth homes and placed into foster care or adoption. 1 out of every 3 Native kids. That is a lot of kids. And there was a concern that had been growing and getting more voice in American politics since World War II, that not only were so many Native kids being removed from their homes and placed into foster care and adoption, but that the practices around foster care, removals and placements really didn't follow the same protocols that they did for most other American children. For example, at the time of the Indian Child Welfare Act in 1978, 74% of the Native children who were removed from their homes never even had a social worker come visit the house. But they were passing judgment about fit or unfit home based on very little evidence. And in fact, the de facto practice had been to simply shift the burden of proof to Native families. And the Native families had to prove that they were fit parents, as opposed to there be an assumption that the parents are fit parents and that the county had to prove that they were not fit parents in order to remove the kids. There were many, many other concerns and data points. And in 1978, the U.S. government had convened lots of people to provide testimony before both houses of Congress, and eventually came out with the Indian Child Welfare Act. The intention and purpose of the Indian Child Welfare Act was to support and strengthen Native families and to provide for the best interests of Native children. What the legislation said was simply this. First of all, if any child of any group is removed from their parents, there's going to be a disruption in the familiar home life. Sometimes children do need to be removed from their parents because there's substance abuse, neglect, abandonment, sexual abuse, something horrible happening. And so when that happens, for any child that's removed, they have this disruption, But for these Native children, since 99% of the adopting and fostering families were white, there was also the disruption of having that child removed from their community and from their indigenous culture. And so the Indian Child Welfare Act said this: when a Native child is removed from his or her home through a foster care petition, they have different names for the petitions in different states. I'm resident in Minnesota, and they call the petition Children in Need of Protective Services, but there are different labels for various other states. But when that happens, that the court is obligated to inform the tribe to which the child belongs. And then the tribe would have the right to intervene in the case, meaning simply they could send a representative from their social services program to appear at the court hearings and say, here's what we think is in the best interests of this kid. The second thing that the legislation provided was guidance about how a child who is being removed from his or her home should be placed. And so that they would evaluate the preferences of the parents and the child, if the child is old enough to share their preferences, and that they would first look for a relative foster care placement, see if grandma, aunt, uncle would be willing to receive the children and foster them. This would maintain, the connection of that child to their extended family, community, and culture. If there was no one available for a relative foster care placement, that they would then look for a placement with another Native family from that same community, so that even if there's a family disconnection through the foster care placement, that there would actually be still some sort of community and cultural cohesion for that child's experience. If you couldn't find a relative foster care placement or a community indigenous placement, that they would then look for placement with another Native foster family. And only after exhausting all of those would they open up to placing that child with any other willing foster home. That was what the legislation said. And the legislation did have some impact. However, it wasn't as remarkable of an impact as you might imagine. So the number of, the racial demography of the fostering families for Native kids went from 99% white families down to 79% white families. Now, that was a big change, but it wasn't a complete reversal of the practice like many thought it might be. There were problems with the legislation. It didn't provide money for training anybody on what the legislation said. In most foster care petitions, the child would never appear in court. So all of the information that's being gathered is coming through, social workers, court personnel, and things like that. And usually, I've sat through on a number of CHIPS petitions, Children in Need of Protective Services petitions here in Minnesota. And, the first hearing is at 72 hours after the child has been removed from their home. Nobody knows, except for maybe a social worker who may have seen the child in the middle of the night, much of anything about the child. And so how do you know that that's a Native kid? A lot of Native kids might look brown, but some of us look white, look black, or look racially ambiguous. So unless you're asking, and unless someone is there who knows something about the kid to actually answer the questions, you really don't know. In the petitions that I have sat in on, the judge usually does ask, is this a Native kid? And if the social workers don't know the answer to that question, the judge will say, please find out and let me know at the next hearing. And then they schedule the next hearing. But it took a while for that to become a more common practice here. And it is not a common practice in equal measure in all places. Lots of people fall through the cracks. In addition to that, the legislation does not say anything about Canadian First Nations people. Indigenous people from Canada who might be resident in the United States. Doesn't say anything about folks who are not enrolled or eligible for enrollment in a federally recognized tribe. And so it doesn't cover the entire Native population as effectively as we had hoped it might. However, once that process begins, most states move to a permanent placement of that child within a year. And if information doesn't come quickly, not everyone would know to intervene. Also, social service budgets have been hacked and slashed and cut so much that there just aren't enough social workers to do all of the different kinds of work as thoroughly and effectively as it should be done. And while the people who take those jobs are doing heroes work, they care about kids, that's why they're doing it. At the same time, they are overwhelmed and understaffed, and that affects the families who are coming into and through the system. Now, there were some effects from the Indian Child Welfare Act, but since it wasn't the complete overhaul that we had hoped for, there's really need for more strengthening of the legislation and more training around it and financial supports for it. However, there has been quite a bit of pushback, and right now there are 3 major court cases which have made it all the way to the United States Supreme Court, which really are likely to have a tremendous impact on the legislation itself. And although we don't know for sure, I think it is pretty likely that some of the provisions of the legislation will be stripped, or that the entire law will be thrown out. And here's what's behind it. By the way, if you want to do a deeper dive, I could recommend the podcast series called This Land, and it is a remarkable series. Season 2 is all about the Indian Child Welfare Act, and they go episode by episode into a much deeper dive into what's going on with the legislation. Here are the major things that are behind the pushback against the Indian Child Welfare Act. Number 1, there has been a tremendous change in adoption practices in the United States. So if anybody listening was old enough to be around in the 1970s and 1980s, during that time, there were a lot of white foster families or white families that wanted to adopt children who were getting kids from China, Vietnam, India, and Pakistan. However, starting in the early 1990s, there was a major change in those practices. Most of the countries of origin started to restrict the flow of their children to American adopting families. And adoption is not just a family practice, it is a big business in America. A typical adopting family will spend about $50,000 in fees for adoption agencies and lawyers. It's a really hefty amount of money. But now these big adoption agencies did not have enough kids to fill the needs of all of the prospective adopting families who wanted to take kids. And this demographic shift in practices, these other countries, China, Pakistan, India, Vietnam, restricting the flow of their children to America, really impacted the business side of the adoption universe in America. And so there were many adoption agencies that started to advise families about a different pathway to getting kids. So keep that in the back of your mind while I now explain this. Foster care is not the same as adoption, and they don't have the same purposes. Obviously, adoption is about getting permanent placement of a child and raising that child as your own. Foster care is designed to temporarily remove a child from a dangerous circumstance, physical abuse, sexual abuse, neglect, abandonment, or what have you, and temporarily remove them so that the government could provide both a carrot and a stick to the parents, so to speak. So the court would mandate that the parents have to get chemical dependency assessments, for example, go through treatment, show consistent gainful employment, and things like that. And if the parents did all of those things, the goal with foster care was to reunite the child with their birth parents. However, if the parents did not or could not do all of those things, then the safety of the child was a higher priority. And so foster care, which was designed to keep families together, was very different from adoption, which was about getting those kids out of families and placed with new ones. But now that there was a challenge to the flow of children to prospective adopting families in America, the adoption agencies were recommending that their prospective adopting parents get licensed as foster care providers, and then seek the placement of children with them as foster parents, and then move towards a permanent placement of the children with them as foster parents so that they could then petition for the adoption of the children that they are fostering. And so although it's a longer route towards adoption, that this would actually increase their yield, that they would actually get more kids into adoption this way. And what happened is the efforts of adopting families and the adoption agencies in the adoption industrial complex served to undermine the spirit and intent of foster care, which is to provide temporary placement pending the rehabilitation of the family from which the child was removed. So that is one thing that is behind this pushback on the Indian Child Welfare Act. There's much more too, though. And this part is actually, although not surprising, really disturbing. Native people in America, tribes and tribal people, own 2% of the land in America. The 2% of the land in America that is controlled by tribes holds 33% of America's fossil fuel reserves: coal, oil, and natural gas, as well as precious minerals. So lithium, which mainly has been coming from Russia, some parts of Africa, and native lands in Nevada. Coal, which is abundant in tribal lands in the American Southwest, and oil in the Bakken, in North Dakota, and in Oklahoma. Tribal lands house 33% of America's fossil fuel reserves. Tribes and tribal members who elect their tribal leaders usually favor environmental protections and a more holistic approach to the stewardship of land and resources. So oftentimes tribal members are opposed to clear cutting, opposed to mining, opposed to pipelines and fossil fuel extraction. And as a result, tribes have become increasingly strong in their resistance to fossil fuel extraction in America. And because of this, there has been a concerted effort to undermine not just, tribal resistance to fossil fuel extraction and transportation, but to actually undermine tribal sovereignty itself. Because if tribes don't exist, they cannot be an impediment to the extraction of fossil fuels. And it is not an accident that the cases on the Indian Child Welfare Act, which you would think have something to do with Native children, that they are being litigated at the Supreme Court by fossil fuel attorneys. Because there is such a political dimension to this. The adoption universe is connected with and enmeshed with the evangelical Christian community, the corporate interests who are interested in fossil fuel extraction are also deeply enmeshed in American politics and are using their tools and resources to shape and influence the policy efforts of American politicians. And so there's actually this triumvirate of the adoption industrial complex, the fossil fuel industry, and right-wing politics in America that are working together to try to erode and destroy tribal sovereignty and see overturning the Indian Child Welfare Act as a means towards that end. There, of course, are all kinds of dimensions to each and every case in and of itself. There was a famous case called the Baby Veronica case, which was an Indian Child Welfare Act case that had extenuating circumstances that were not well publicized at the time of the case. The mother of this child, in this case, biological mother, was white. The biological father was Native, and he was serving in the military and deployed overseas on back-to-back deployments. The mother messed up. The child was removed from her care, put into foster care. There was a little bit of communication with the father through his own mother, and she apparently had expressed some interest in maybe receiving the kid, and he was busy with his deployment and couldn't show up for court hearings and things like that. There's actually a significant question about how well the court did at servicing papers and informing him of the actions affecting his biological child. But the end result was that this child was placed into foster care. The father finally got back from his deployment and said, "Hey, that's my kid. I want to raise my kid." And went to court, and since he was Native, he invoked the Indian Child Welfare Act in his defense. And the end result was the white foster family appearing on CNN and other television networks, crying their eyes out and saying, "We love this kid. We're the only parents she knows. This law is racist. The only reason we're not being allowed to take care of her is because we aren't Native." And man, their tears were tugging at all kinds of heartstrings in America. But what was excluded from the coverage was an understanding of the parental rights of the dad and also the context of the Indian Child Welfare Act. In the end, that man lost custody of his kid, in spite of the legislation. But that also fanned the flames. Look, this law is racist. It needs to be fought. It can be fought. And one of the first cases that is coming before the Supreme Court involves the adoption of a Native kid by a white family. And that family has already adopted the kid. But the case was filed and the litigation began 2 weeks before the adoption papers were signed by the court, even though the outcome was already known. They weren't litigating this to look out for this kid. They found a perfect example that they could use to start litigating against the Indian Child Welfare Act, regardless of the fact that this child has already been adopted by this white family. And so I am personally concerned about where this ends up. I do think that, The cases that Native people have won more recently with the Supreme Court of the United States were different kinds of cases. And even a justice like Gorsuch is actually like what they call a literalist. He just looks at the US Constitution says treaties are the supreme law of the land. Only the US federal government can do something to treaties, and they never did. So there's still a reservation there, and the tribe has jurisdiction over the lands within that reservation. And that was a much easier case for them to decide. But with the political bent of the court and the likelihood that they are going to do away with affirmative action, they will probably focus on there's something racially specific about this legislation and nothing should be do away with the legislation. And I think the likely effect is that the gains that we saw in strengthening Native families and communities and sovereignty through the Indian Child Welfare Act will be overturned, either eroded or overturned and done away with. And I think it might foreshadow some really significant attacks on tribal sovereignty that will be ongoing and forthcoming in the years to come. Miigwech. Thanks for watching today. I'm Anton Treuer. Let's keep in touch. I'm active on social media, and my website has lots of information on my books, speaking engagements, resources for the Ojibwe language, teachers, and more. Miigwech.